Hi, my name is Gregory Dell with the law firm of Dell and Schaefer, and I'm here with attorney Victor Pena. And Victor, a recent case came out that was very favorable for plaintiffs, which are claimants across the country, and this is a case against MetLife, and we've handled thousands of cases against MetLife. It's not a case that we handled because obviously we can't handle every case across the country, but we track all of the cases because case law is precedent and it affects other people and all of our clients around the country. So give us a little bit of background about this case against MetLife, and then let's talk about some of the things that are takeaways that are going to help our clients and claimants in the future to learn how they can get their benefits approved and keep them being paid.
Sure. Well, this case involves a very common limitation that you typically see in MetLife policies. The neuromusculoskeletal limitation usually applies at the 24-month mark, and it's always broadly defined to include basically any spinal, any deformity disorder of the spine or extremities or the surrounding soft tissue. But in this case, it involved the claimant, and she had been paid for 2 years. She had a long history of back disorder.
So just to clarify, this is a tool that MetLife uses to deny benefits, saying
Right.
that this is an exclusion, that if you have or don't have these specific neuromusculoskeletal type conditions, then we don't have to pay you anymore.
Right.
Even though we paid you for those things during the first 24 months.
Right, exactly.
Okay.
So it's very broad, and there are certain exclusions to this. So there are certain exceptions. If you have one of 6 of these exceptions, then the limitation doesn't apply. So you have to have objective evidence of, for example, radiculopathy, which was the case in this particular case.
Right, and we're always trying to get our clients around that neuromuscular limitation so that they can keep getting benefits till age 65 or whenever the policy ends.
Right.
Okay, so what happened in this case?
So this claimant, she had a long history of back disorders, a lot of back surgeries. And then she suffered another injury that basically made her, or had forced her to file this claim for disability benefits. So she had a doctor that, her primary doctor supported the existence of this lumbar radiculopathy, post-laminectomy syndrome, and they still cut her off. So they weren't able to get an MRI in time that the doctor later submitted after she'd received this denial letter, which he felt was supportive and established the existence of a radiculopathy, even though there was no actual affirmative proof that there was any nerve impingement. So she had to go through this appeal. With the appeal, she did do an EMG, which is usually a test that you do to establish or show radiculopathy. Here, the examiner had interpreted it to show that there were some nerve abnormalities, and in his opinion, it established the existence of radiculopathy. Interestingly, MetLife had their medical director review. He acknowledged the radiculopathy, and then MetLife took it a step further, which is what they usually do. They send it to then be evaluated by another doctor for functionality. So the medical director said, okay, radiculopathy, acknowledged it, and then another doctor was going to see if she was functionally limited.
Right, I want to just clarify something so people know this. When you have this test, whether the EMG or the nerve conduction study test, they're two very similar tests. They're often administered at the same time. It will confirm whether or not you have a radiculopathy. It doesn't tell you, like when the medical director says, yes, there's radiculopathy, okay. It doesn't say level 10 radiculopathy, level 1 radiculopathy. It doesn't mean that you're disabled. It doesn't tell you, oh yeah, that person's in extreme pain or no pain. So it's important to know that. It's just a confirming tool to say there is some kind of nerve impingement. So just when someone's looking at it on paper, MetLife, who've never even seen this person, they look at it, then they send it to this other doctor. So I always find it fascinating how they can come up with some decision about the level of the person's pain or functionality. So when you said they're sending it to another doctor for functionality based upon the EMG tells you nothing about functionality. It just says, yes, this person has radiculopathy.
Right.
Okay,
Exactly.
so you were telling us
their whole point was to look to see if there was an exclusion that would apply to get her outside the scope of this limitation, and then they look to see, okay, now is she limited to the point where she can't work? So the case got interesting here because this outside doctor, Dr. McPhee, they sent, and the questions were specific to what's her functionality. So this doctor actually said, yeah, because of her long history of back surgeries, her chronic pain, she's limited from working. However, he took it a step further and decided to question the diagnosis for radiculopathy at that point. Nobody asked him about radiculopathy and whether or not it was confirmed. The medical director had already confirmed it. But he took it that step further, questioned it. MetLife at that point decided to ignore their medical director's opinion, decided to ignore the treating physician's opinions, and said, okay, there's no, the claimant didn't establish or provide objective evidence of radiculopathy, the limitation applies, and they upheld the claim, or their decision.
And that was on appeal.
That was on appeal. So MetLife, they usually give the opportunity to review. So when they do these outside reviews, they'll give the claimant the opportunity to have their doctors respond, which is what they did here. So they went back and forth with this Dr. McPhee and her treating physician. Her treating physician obviously disagreed. So Dr. McPhee said, okay, he stuck with his opinion, but said that it would be beneficial to have her undergo an independent evaluation or additional testing. Instead of doing that, MetLife, just one day after Dr. McPhee sent this addendum report, they upheld the decision, denied it. They didn't request any additional information. So at that point, of course, she filed a lawsuit. She lost at the district court level. They took it to the Court of Appeals, and then the court sided with her, saying that, basically finding that MetLife was arbitrary and capricious for essentially just completely disregarding Dr. McPhee's opinion that additional testing should be done. So it was remanded, of course. They didn't award her benefits. They remanded it back to MetLife and said, review it again, basically telling them they have to do an outside independent review.
And that's where we stand.
And that's where we stand.
So this battle is still going. The claimant kind of got a second breath of fresh air, but lost at the court level. So people understand, you go to the district court, then you can go to the appellate court, and then you can try to go to the Supreme Court, but the Supreme Court only hears 100 cases a year out of the whole United States, so the chances of the Supreme Court hearing it is like non-existent. Mm-hmm. And now, several years down the road, because it's now been through a district court case and an appellate court, it's now going back to MetLife. The claimant still has no benefits, and MetLife now is going to hire some outside doctor to look at it, and we don't know what's going to happen. So this claimant could still, at the end of the day, MetLife gets this review, the independent doctor says, no, we don't think you have restrictions, limitations to support it, and now we go back to court and litigate the whole thing again. So it's a vicious cycle. No matter how good your lawyer is, you're still going to be engaged in this particular process. Now maybe, I don't know, if this claimant had representation during the appeal, which is really important, it shows how important it is to put in the best appeal possible to try to cut this thing off at the pass. You also learn from this as a person who might be in this situation is that when you get involved in litigation, it's a long, drawn-out process, and it can keep going and going, and at the end of the day, you think you win, which this is a win for the claimant to still be alive and still have a chance to win this case, but you still not getting paid, and it's still ongoing, and if you go back now to the district court, which is where you have to go, if they don't approve the claim, and you lose, then you got to appeal again, so you could be another 2 or 3 years. It's ridiculous. We just did a video earlier today. The decision came down 10 years after the person initially was on claim. Wow. Now that's exceptional, but this is a case that's could be litigated for 4, 5, or 6 years,
This
which
one
is
was
outrageous.
4 years, I think,
already
after the
4
initial
years.
denial.
So this case is going to go on. We're going to read about this case. Hopefully not, but we may be reading about this again in 6 years from the initial denial, which is ridiculous. So, well, it's always good to see a case against MetLife where the neuromuscular limitation is being kind of picked apart and overruled, because we deal with that every day, that particular limitation. Hopefully this claimant will win. Again, it's not our case. We're not handling it. If you have any questions about a MetLife claim or any long-term disability insurance claim with any company, Victor or any of our attorneys are available to help you. We always offer a free initial phone consultation. We help clients all over the country, and we look forward to the opportunity to speak with you.